Hello and welcome to tutorial key points number 4. What we looked at here was a review of the first part of the course initially. We looked over UK constitutional law, and I highlighted the importance of making sure that you fully understand separation of powers, parliamentary sovereignty and conventions. We then reviewed the principles of human rights, and again the key things to focus on in your review are the traditional and the modern approaches, the European Convention on Human Rights and its key provisions, and specifically the rights that arise upon arrest, being taken to the police station and whilst in custody. And as I've suggested in previous tutorials and videos, it would be very worthwhile you making a table showing what the rights are, when they apply, what's the relevant statutory authority for it, and any exceptions to the rights and when those exceptions might apply. On criminal law, obviously it's those definitions and application of actus reus and mens rea. We spent more time on reviewing obligations, specifically on what contract is about and the tort of negligence. So in contract, the first question that needs to be asked is there a contract? And that's where the essentials of a contract come in. The offer, acceptance, intention to create legal relations and consideration. And the courts use these as tests to decide whether a promise is to be treated just as something which the courts are not going to get involved in, and those that meet those criteria, those ones can be enforced in the courts. So offer, acceptance, it's a way of analysing what's gone on between the parties, and do look at the definitions of each. Intention to create legal relations, again the courts can't see into people's minds, so they work by presumptions. A presumption for commercial arrangements, a presumption for social and domestic, presumptions which can be overcome, and consideration, the price that both parties are paying for what they get from the other. Second issue is what's in the contract, the express terms, things that have been expressed between the party, and the implied terms, some implied by the courts, but the ones that we've concentrated on, those that are there by statute, such as the Sale of Goods Act. And then remedies. On tort, it is just the tort of negligence, and the important things to remember is that for negligence to be shown, you have to show that first a duty of care exists and is owed to the defendant, secondly that that duty has been breached, and thirdly that as a result of that breach the claimant has suffered. The rest of the session we spent on looking at introduction to EU law, and the first thing that I cannot stress enough is that you need to make sure that you fully appreciate the differences between the European Union and the European Convention on Human Rights. Not helped by the media, who often talk about the European Court or Europe has done something. They are two entirely separate concepts, and I'm providing a handout stressing those key differences. They're different courts. The Luxembourg Court is the European Court of Justice for the European Union. The European Court of Human Rights meets in Strasbourg. The European Union, as of today's date, has 27 members, whereas the ECHR, was founded by the Council of Europe. That has 47 members at the moment. So do make sure you've got very clearly in your mind that they are different bodies, because confusing the two in a question comes under the category of fundamental flaw, which is a criteria for failing a question. So never give any suggestion that you've confused the two. In your reading on the European Union, look at the history of how it's developed from a European coal and steel community to the establishment of a European economic community and Euratom as a third, how it's developed through particularly the Single European Act, through the Maastricht Treaty, and recently with the Treaty of Lisbon. Look at those steps. The other area to look at are the institutions. So make sure that you know about the European Commission, the Council of Ministers, the European Parliament, the European Court of Justice. There's some material in your manuals, but you will find on the website europa.eu. Don't need to put www in front of it, and you can choose the language that you access it, but there's a lot of information in a very readable form about those institutions. So do make sure that you've got a good understanding of the institutions, and I say the Europa website is absolutely fantastic for the information that it provides about each of those institutions, what roles they play, particularly in the legislative process, but also in the day-to-day workings. You're going to be studying the European Union for the rest of this course, so do make sure that you get a good understanding of it. And so sometimes the British media are not the best place to go to. There's a lot of nonsense spoken about Europe. Go and make sure that you know the facts, and it will make you one of those irritating people that will be looking at newspapers and television reports and statements that are coming from people and we say, "Ha, wait a minute, you've got that wrong. You may be confusing the EU with the European Convention on Human Rights. You'll see instances of Europe being blamed for bad things and the good things being decided back home, whereas actually member states work together on many issues. Finally, ETMA 03 due on the 22nd of May, and if it's not in by that date, if you haven't got a prior extension, then if it comes in after that date, I will not be able to mark it. So this one is statutory interpretation, but it's not about the principles of statutory interpretation. So anybody that writes about the literal rule, the golden rule, and so on will not be answering the question set. How to prepare for it? Get used to reading statutes generally. There are lots of common words and phrases that you'll find, and although at first they can look quite terrifying, you'll find that actually statutes have a very simple structure, and the more you look at them, and previously I've sent out some statutes and some points on interpreting statute. Do make sure that you've got the practice in before you put it before you do the TMA. Spend some time on the extracts that's in your book, but again, not on the commentaries on it. Not only are you not going to be credited with anything that you've got from outside, because the questioner specifically said not, irrelevant material that is brought in from that will actually be marked down. This is about you demonstrating that you can look at a statute and use it and apply it and gain the understanding from it. When you're analysing an offence, the three things that you need to look at is the wording of the statute. Someone is guilty of such and such offence if, and then the necessary elements. Look at those elements, logically split them up and say that it needs to be this and this and this. Consider whether it's an act or whether it's a mental state, and do think this one through. Don't jump to conclusions, because sometimes you need to reflect further as to whether something that might look like an act actually is a mental element, or something that might look like an mental element actually is an act. So do think that through. So practice is going to be really useful before you do this TMA, and I look forward to receiving them on or before the 22nd of May. Thank you.